Now, before I turn it over to the panel members, let me encapsulate very, very briefly this administration's approach toward the unitary executive. Reduced to its most basic terms, the unitary executive concept is interpreted and implemented by the current administration. Rest on the premise that when the chief executive acts pursuant to his Article II constitutional authority as commander-in-chief, he may exercise this authority unfettered by either domestic or international law. In brief, when the President, as Commander-in-Chief, exercises his authority to protect the security of the United States, he is, in fact, above the law. This administration's exceptionally broad interpretation of executive authority and power is, surprisingly, not a post-9/11 invention. It was espoused 20 years ago by, guess who? Then Congressman Dick Cheney, in his dissent to the 1987 Congressional Iran-Contra report. In his view, the President would, and I quote here, on occasion feel duty-bound to assert monarchical notions of prerogative that will permit him to exceed the law, unquote. A more explicit recitation of this commander above the law theory, as some refer to it, has been set forth in a series of recent opinions issued by the Justice Department's Office of Legal Counsel. The line of reasoning contained in these OLC opinions is exemplified by the following passage, and it's an interesting passage. The text, structure, and history of the Constitution established that the founders entrusted the President with the primary responsibility and therefore the power to ensure the security of the United States in situations of grave and unforeseen emergencies. The decision to deploy military force in the defense of the United States' interest is expressly placed under presidential authority by the vesting clause and by the Commander-in-Chief clause. In particular, as an affirmative grant of authority to the President. In addition, the structure of the Constitution demonstrates that any power traditionally understood as pertaining to the executive, which includes the conduct of warfare and the defense of the nation, unless expressly assigned in the Constitution to Congress, is vested in the President. The implications of constitutional text and structure are confirmed by the practical consideration, and this is interesting, that national security decisions require the unity and purpose and energy that characterize the President rather than the Congress. Now, in terms of the specific application of this theory to an issue that we're going to be discussing this afternoon, the OLC opinion notes the treatment and interrogation of U.S. held detainees. It says, even if the interrogation method arguably were to violate Section 2340, and that's the U.S. statutory implementation of the Convention Against Torture, the statute would simply be unconstitutional if it impermissibly encroached on the President's constitutional power to conduct a military campaign. We'll come back to that. As Commander-in-Chief, the President has the constitutional authority to order interrogations of enemy combatants. Any effort to apply Section 2340, the statutory provision, in a manner that interferes with the President's direction of such core war matters as the detention and interrogation of enemy combatants, thus would be unconstitutional. So in its simplest terms, ladies and gentlemen, the unitary executive concept in the view of this particular administration stands for the proposition that when exercising the constitutional grant as Commander-in-Chief, the President is possessed of the authority to vitiate any provision of either U.S. or international law that he unilaterally deems an encroachment upon not only his war-making authority, but more comprehensively, his power to conduct any military campaign. That, in a very encapsulated format, is this administration's take on the unitary executive concept. So we'll turn to our panel members now. Our first speaker will be Bob Turner, who has been introduced. He'll be followed by Sean Watts, and Bill Banks will conclude this presentation. We'll make an attempt to leave about 10 minutes so that we can entertain questions from the audience. Bob is a big fan of the unitary executive concept. My question to him from the very get-go is whether he's a fan of the unitary executive concept as interpreted by and implemented by this administration. Okay? Bob, I'm going to hold you to your 15 minutes. Okay?
Give me my warnings. I know that. I have an impossible task here. I wrote a 1,700-page doctoral dissertation on foreign affairs and the Constitution with 3,000 plus footnotes. I'm going to give you about 1/1,000,000th of that, but there's some background I think you need to know. The unitary executive is not per se an evil thing. The administration has made some horrible decisions. Some of you may have read my Washington Post op-ed attacking the executive order, saying that we can essentially torture detainees as long as our purpose is not to humiliate them, which was outrageous. But it's very important to understand the constitutional power and to uphold the Constitution. The Founding Fathers debated the idea of having a plural or a unitary executive. They agreed to have a unitary executive. All executive power is vested in one person, the President. He has a large branch of government to help him execute those powers, but the powers belong to him. That's not really controversial. The real issue is the ways it's been carried out. This administration has gone farther than most. But I would argue much of what they've done is to try to take us back to the pre-Vietnam understanding of the Constitution. Just some of the arguments that are made. The president, they say, is the sole organ of foreign affairs. I remember George Will had an op-ed just attacking this, not understanding that it came from the earliest days of the Constitution. The president has unchecked powers. In a democracy, we all know you cannot have unchecked powers. The president has authorized warrantless wiretapping without complying with the Foreign Intelligence Surveillance Act. Executive privilege claims have been made to deny information to Congress. Obviously, in a democracy, Congress has a right to all powers, it is argued. The president has issued signing statements refusing to be bound by various statutes. Let's look at some of these. Does the president have unchecked powers? When he claims to do that, is he really acting as King George instead of President George? Have we forgotten Marbury versus Madison, where Chief Justice John Marshall, in our most famous Supreme Court case, said by the Constitution the president is invested with certain important political powers in which he is to use his own discretion, and whatever opinion may be entertained in the manner in which executive discretion may be used, there exists and can exist no power to control that discretion, not in Congress, not in the courts. He went on to say the subjects are political, they respect the nation, not individual rights, and being entrusted to the executive, the decision of the executive is conclusive. And as an example, he mentions the Department of Foreign Affairs, what we today know as the Department of State, and he says this officer is to act to the will of the president, and the acts of such an officer as an officer can never be examinable by the courts. What about the sole organ doctrine? Where does the Constitution give the president all this control over foreign affairs? It doesn't even mention foreign affairs or national security. The answer is clear. Article 2, Section 1 says the executive power shall be vested in a president of the United States, not in the executive branch, not in the president, his subordinates, in the president. Lou Hinken, one of the leading authorities on international law in this country for decades, noted the executive power was not defined because it was understood by framers raised on Locke, Montesquieu, and Blackstone, all of whom argued that the control of foreign affairs, of war, peace, leagues, and alliances was an exclusively executive power. We modified that. We gave Congress and the Senate certain checks, but we did, in this clause, vest in the president the general control of foreign affairs.